Ron Brown on behalf of Mr. Calhoun.
Andrew Childers appearing on behalf of PPR.
Your name, sir?
Jules Calhoun.
All right, thank you. All right, this is it's entitled People's Ex parte Motion for Modification with Bond Conditions. I don't know that it was as filed ex parte in any respect whatsoever, because I think it was communicated to all parties. That's the first problem. The other issue is that typically these motions are filed. Court's first determination is whether or not the necessity for the court's action constitutes an emergency. I'll be frank with you, I'm not convinced that it does constitute an emergency, but given everything, the court is choosing to hear the matter. I really don't deem it an emergency, so that you're clear on the court's perspective. All right, but is your motion? Go ahead.
All right, before I begin, and thank you for that, thank you for accommodating this motion. Because I'm a little unclear. I talked to James and Ms. Scott from the defender's office. My understanding is there was one order, and I think there was an error or an issue with what are specifically the defendants with respect to GPS tether and exclusion zones. What are those conditions if nothing changes with respect to the defendant's bond as we sit here today?
The original order that was entered by the magistrate on the 28th, and I'd have to go back and look at the hearing, but I don't know that there was necessarily an objection from the people, was for location tracking only on a GPS tether.
Okay.
That subsequently, and again, I'd have to go back and look at the hearing. I did not have the time to review the video of the hearing. That has subsequently been changed to exclusion zone with location tracking only. So the change wasn't to, just added an exclusion zone. And the only area that was added, which again doesn't, when I look at the requests, the written requests that were made by the people, doesn't make much sense to the court, given my knowledge of the area, is the address of Hazley Elementary School, Ann Arbor. That particular address is the hot zone.
Is Hazley Elementary School.
Is Hazley Elementary School.
And so that, as the order currently stands, if the defendant were to be released, there would be exclusion zone of the elementary school on its GPS tether.
As I read this order, yes, but again, given my knowledge of the area, I have concerns about how this is written, because and I'll just lay it out to you. I mean, I'm one that is full disclosure. Hazley Elementary School is my elementary school. I know people didn't think it existed way back with the dinosaurs, but it did. There are 4 entrances to basically 4 access points to the Hazley School grounds that come off of different neighborhood streets into there. So listing just the address, I don't know, quite frankly, is specific enough to cover the area. I mean, for the most part, most of the people that, if they were walking there, would not enter necessarily off of Duncan Avenue. They just, so that's what I have.
Okay, and thank you for that, Your Honor. I know, obviously, we were with each other less than 24 hours ago.
We were.
And that's why I wanted, before we get into anything, I just wanted to make sure that my at least as correct as it could be. So the motion that was filed by my office last night is requesting a $2 million bond with the otherwise with a house arrest with GPS tether with release, and for him to not be within a mile of any school. That would be the request. The concern, my understanding, the concern that gave rise to this renewed request, because at the time of the arraignment, that was not the request of the people, was that the learning of the defendant's.
Well, let me just stop you because I don't think that that's true. At the time of the arraignment, and this is something, quite frankly, that people are going to have to explain to this court. There was an original bond request sent for, in terms of its monetary amount, for the $250,000 cash assurance. That was, as best I'm able to determine, sent on the 17th. Or shortly, the original one for the $250,000. Within 5 days, there was then a new bond form for the $2 million with some other added changes. I've, as best as I could on short notice, reviewed those. What I do not understand is, and just so I'm clear, so at the time of the defendant's arraignment, both of those were before the court, before the magistrates, both bond forms. This request for the $2 million was before the court at that time. What could not be explained, and I think something that's going to have to be explained by the prosecution, is why the request, particularly for the monetary amount, is changing. Because I don't see any basis as to why, in essence, almost an 8 to 10-fold.
Now this is where things get intense. The judge is calling out a massive jump from $250,000 to $2 million with no new evidence. That's not just unusual, that's a red flag. In the legal world, bond isn't supposed to be punishment. It's about ensuring someone shows up to court. So if the amount skyrockets without justification, it starts to look like a workaround to keep someone locked up. Is this about risk or control?
Justify that.
Only response I can give to the court would be to rely upon the written meetings. I have no personal knowledge or information.
Well, okay, and I get that, but isn't that important? I mean,
I don't disagree with the court.
because effectively what you're asking me to do is to do something under the court rule, which I can't do, which is to deny the defendant bond. I mean, a $2 million bond will be effectively a denial of bond for this individual, from my understanding. I've had my mini tirade. You can go ahead.
I understand the position of the court. As I stated, I'm relying upon the pleadings that have been filed. I think that at this point, I would move my discussion on, if the court's willing to an exploration of modification of the GPS tether, or at least clarification, hearing what the court, through its own personal knowledge and experience of the location of Hazley Elementary and the location of the defendant's residence. My understanding is that there is perhaps a residence the defendant can stay at his uncle's home, on, I believe it's Ingalls, just kind of other, slightly more downtown, you could say. Now, in a quick look on Google Maps, that address does appear to be within a couple blocks of Community High School. I don't know if the court is entertaining, would entertain. I'm just kind of, as we do sometimes around exploring options on the record.
Right. No, I get you.
And so, that's kind of where what I'm looking at now. Ultimately, we have a lot of people in the courtroom. I believe the majority of these people in the courtroom are staff at the elementary school that were affected by this threat. They are concerned for their own safety. They're concerned for the safety of their students, rightfully so. I have a child in elementary school, and the court has its own experience as such. I think that what ultimately we're looking to do is anything we can do, acknowledging the fact that the defendant may very well be out of custody while this matter is pending, that we can as best protect the children of that school and the community at large. And that's what the people are requesting. And I'm open to a discussion as to how we can best do that. And I'm very much aware of the defendant's history. I guess I wouldn't say I'm very much aware, but I'm aware of the defendant's both mental health issues and what I could say the condition that he exists in through a brief reading of the police reports, as well as discussion with members of the public defender's office. I'm aware of all of those things.
Okay, so, and then certainly I'll hear from the defense, but there was a request that he not go within a mile of any school, right?
You have to leave the city of Ann Arbor.
Absolutely. I mean, because I even this morning was having my staff look and just try and determine whether or not that's even a feasible condition I could put on a defendant. And a mile, you can't do it. I mean, I think within really a mile and a half, 2 miles of just Hazley School, there are.
And here's the pivot. When extreme restrictions don't work, like banning someone from being within a mile of any school, the conversation shifts to something more realistic: house arrest. This is classic courtroom negotiation in real time. Both sides are adjusting, testing boundaries, trying to land on something the judge will actually approve. But think about it. Is house arrest a fair compromise, or just the least problematic option on the table?
The exclusionary zone game.
I would certainly entertain it. And look at it if that's the request. And Mr. Childers, I realize you're here and I always respect the arguments that you give, and you always give good arguments to the court. I'm trying to figure out what specifically are the people asking the court to do. Because when I look at the motion, the request is really threefold. That the people want his bond increased to $2 million cash surety from the current $250,000 cash surety. They want him to remain under house arrest with a GPS tether if he's released, and that he can't go within 1 mile of a school. And so, I mean, is that the people's request, or?
Be possible if we could take a brief break. I didn't file the pleadings, obviously.
I know, Mr. Childers, and I understand that sometimes we're put in a position of having to argue something, but so that you're also clear, I mean, I take what is at least alleged, the safety of the students, the safety of the community very seriously. I can tell the people out there that people that have known me, I've been on the bench 25, 26 years. You can send me all the emails you want. That doesn't affect it. I'm going to issue my decision based upon how the law reads. So you can stop sending the emails because, quite frankly, they don't get to me until afterwards, and they have no effect on me. I need to know what the people want, what the defense wants, and then I'm going to make the call. And there are going to be those that don't like it. There are going to be those that like it. But that is irrelevant to me in a lot of ways. I'm not here for a popularity contest. And I think there are some people that need to realize that in terms of what they file before this court. I don't play a popularity game. I do my job. I will give you a break. You can take the defendant back and we'll come back out and I'll hear from the people and the court stands in recess.
All right.
Court Rico's case of the people versus Jules Calpho.
Andrew Childers appearing on behalf of the people.
Ron Brown appearing on behalf of my client, Your Honor.
Right.
Thank you, Your Honor. I appreciate the opportunity. I've spoken with the chief assistant, the elected prosecutor, and the petition that we are requesting, I would call it modified off the written pleading. What the people are requesting is and I don't believe in my discussions with the public defender's office, this is something that they're opposing. The house arrest at the uncle's address on Ingalls, so it'd be a GPS tether with house arrest. Commander Shipakasi from the jail has been or is currently in communication with the deputy chief at Ann Arbor Police and coordinating with the uncle to have Ann Arbor Police go through the residence prior to the defendant being tethered there to ensure there are no weapons in that home. And I believe that we would allow the defendant has medical appointments at CMH and a doctor. We can figure out those details, but we would allow for release to verified medical appointments from the Ingalls Road address.
Right.
That's correct, Your Honor. We'll hammer out the details and present an order to the court.
Well, you'll figure out the details of the appointments.
We have the appointments in the address. 2 at CMH and 1 with a Dr. Connolly, whose office is at 3300 Washington Avenue, right down.
But are those regular appointments? So they're going to occur at a particular time or what?
Through today, for the next week, we know of these appointments. But once he's seen, we don't know when he will be seen again or scheduled again. They're intake assessments.
Thank you.
And my understanding.
That's right. What did you hear?
I'll go sit down.
What? Oh, no, you're fine. I'm just saying. I knew somebody knew something more than most.
Of course. Usually in my experience, if we allow for them to, there can be an aspect where the defendant is communicating with community corrections.
Correct.
If this particular doctor, I know appointments change and things like that. We don't need to have an order reflecting every single appointment. But the people we would have no problem provided they are verified with the defendant seeking the treatment at CMH and with his doctor.
All right. So just so that I'm clear, the request for the increase in bond, the monetary amount is withdrawn.
They're no longer making that request.
The request for exclusion zones is not needed only because he'll be under house arrest.
Right.
All right. And then what did I say the other one was? All right. So really, the second one is just a modification of GPS tether to a house arrest.
House arrest, correct.
All right.
And Brandon Casey from Community Corrections was already sending me messages that they're aware of this address and
They're aware of the Ingalls address.
Correct.
All right.
Your Honor, we've also spoken to the owner of the 110 North Ingalls address, and he has consented to the police search of his home for weapons.
All right. And that's a single.
It's an apartment. It's an apartment.
It's an apartment. Council approach.
On behalf of my client, should we approach with the answers that the court needs?
No, that's okay. I presuming you checked the concerns of the court
Yes.
and have filed with the court a stipulated order for release from custody, which the court, while in back, has reviewed, finds that it is appropriate, and that it addresses the issues both of the needs of the defendant, which is important, but also not considering him to be a risk of flight, does primarily address the issues of concern and safety for the public on this. And I would note that I believe he has a preliminary examination, or not preliminary, but probable cause conference, which is scheduled before me for this upcoming Thursday.
Yes, Your Honor.
All right, because it was rolled up in terms of time. I appreciate the parties working it out. I have signed that order. What we will do also is we will review it. We'll prepare a community corrections order so that everybody is straight regarding the GPS tether and exactly what's going to happen with that.
Yes, Your Honor.
All right.
So the court's aware, my understanding is it may be happening as we speak, but Ann Arbor we're sending officers to meet the uncle at the address.
To go to the address to make sure that there are no weapons, so that won't be a bar to the release. We will get that over there. For those that are interested in his release, the tether is going to have to be in place prior to his release from the jail.
Understood.
So we will try to make that happen and try to make sure that if it's going to happen today, it can happen today. Otherwise, it's not going to happen till Monday.
Understood.
All right.
And just like that, what started as a push for a $2 million bond and sweeping restrictions ends with a negotiated release plan. No massive bond increase. No impossible exclusion zones, just structured house arrest with monitoring. This is a perfect example of how courtroom dynamics, not just the facts, shape outcomes. So what do you think? Did the system work exactly as it should, or did something feel off along the way?